Thank you. Thank you so much, Volker. Thank you for giving us the opportunity to talk about our position statement, which is a project within the Max Planck Institute, and it's a collective work. So you can see here all the authors we are talking, somehow representing all of them. We have all been coordinated by Professor Joseph Drexel. Now, I will start talking very briefly about the Digital Markets Act, which is the subject matter of our position statement, just for those who are not familiar with it. And then we will go deeper into the topic of our position statement, which is on the implementation of the Digital Markets Act, and in particular, on the relation between the Digital Markets Act and national legislation and national enforcement, with some coordination aspects at the end. Now, first of all, why do we have the Digital Markets Act? The Digital Markets Act is a regulation of the European Union. It has been approved quite recently, and it also its aim is ensuring contestable and fair market in the digital sector. It all started with a consideration. Digital markets are not functioning properly. They are not contestable because of some of the characteristics of the digital markets. For this reason, some undertakings acquired an excessive economic power in these markets, and this also created an imbalance of the bargaining power between digital platforms in particular and their users. Competition law is the traditional legal tool that is used in order to address economic power, but in this case, it didn't work for a series of reasons. And that's the reason why in the European Union, it has been adopted a specific regulation to regulate digital platforms. The main structure is the Digital Markets Act is quite straightforward. First of all, core platform services are identified. So there is a list of platforms that are within the scope of the DMA. Among the gatekeepers operating these platforms, some gatekeepers are designated based on qualitative and quantitative criteria. And these gatekeepers, when operating the core platform services, are now obliged to respect some ex-ante obligations. Now, to go a bit on the substance, here you can see the gatekeepers. They have already been designated. It's possible that new gatekeepers will be designated in the future, but this is what we have now. And as you can see, the gatekeepers are essentially the largest online digital platforms that we have now in Europe. Alphabet with Google, ByteDance with TikTok, Amazon, Apple, Meta, and Microsoft. It's interesting to notice that some of the undertakings that have been designated accepted the designation. Some others are not so happy about that and already announced that they will challenge, or maybe they have already challenged this decision. Of course, then now it's up to the courts to decide whether the designation decision is compliant with the criteria that are established by the DMA. The obligations, there are many obligations that have been imposed. We are not going through all of them because this is not the topic of our position statements. But what is interesting to remember is that the deadline for the compliance with this obligation has not yet expired, but will expire soon. So it's the 7th of March 2014, so 2024, so less than 1 month from now. And some of the gatekeepers already announced the measures that they intend to adopt in order to comply with the DMA. These are contractual, technical measures, but some of the competitors of the gatekeeper, or at least some of the other companies that are somehow active in the digital markets, already announced that they believe that the compliance measures are not sufficient. So again, we will see in 1 month, probably a bit more, we will see if these measures will be considered sufficient to comply with the obligations. What is also very interesting is that Spotify, which is not a gatekeeper, but has strong relations with gatekeepers, of course, in particular with app stores, so with Apple and Google, they already announced that because the gatekeepers will have to comply with the obligations of the DMA, they will be able to provide new services, to provide new products. So the details are still not public, but this is somehow a good sign and tells us that maybe, probably, the obligations of the DMA will be actually able to do what they intend to do, so to open digital markets and to open innovation in the digital markets. One last mention about the enforcement. The European Commission is the sole enforcer of the Digital Markets Act. National authorities have a very, very marginal role. The European Commission will be the one designating the keepers. The European Commission can specify certain obligations, can also propose some amendments, and above all, the European Commission is in charge of opening investigations for lack of compliance by the gatekeepers and eventually imposing fines. Now, let's go to the core of our position statement. We focused on the implementation of the DMA, and in particular, in the relation between the implementation of the DMA and national legislation and national enforcement. So we gave our interpretation to some of the articles, paragraphs of Article 1, Article 1.5, 1.6, and 1.7, that are the main articles dealing with this relation. There are also others, but these are the most important ones, in order to understand how it will work in the future, essentially. But first of all, it's important to remind that the issues that we are going to talk about are part of a bigger issue, which is not new at all. So it's the tension between centralization and decentralization in the European Union. How much power should a European institution have, and how much power should be retained by member states? More specifically, the tension here is between two different interests. On one side, we have an interest of avoiding fragmentation, so having a uniform or at least harmonized legislation throughout the European Union. On the other side, we have the need of ensuring a certain level of autonomy of member states, which can provide their experience, for example, in enforcement, or can adapt their legislation to the different circumstances and different situations that we can have in different member states within the European Union. This is an issue that somehow has been discussed since the foundation of the European Union. Why is this particularly important in relation with the Digital Markets Act? Because, of course, digital platforms are by their very nature ubiquitous. It's easier than in other sectors for digital platforms to provide the same service, to have the same business model throughout the territory of, I would say, the world, but for what we are concerned with of the European Union. And thus the need for avoiding fragmentation is very strong in this sector. And this is the reason why the Digital Markets Act is very focused on centralization. The Digital Markets Act imposes very strong limits to national powers in legislation and in enforcement. This is the first article from which we provided an interpretation, is Article 1, Paragraph 5, which is essentially about the limits of member states to legislate or to give any kind of rules within the scope of the Digital Markets Act. And essentially, Article 1.5 establishes that member states should not legislate within the scope of the Digital Markets Act. And it makes sense, in order to avoid fragmentation. But we have some, let's say, the problem comes when we go deeper in the interpretation of this article. And in particular, the problem is how do we exactly define the scope of the Digital Markets Act? The solution that has been given in this article is focused on the aims, the goals of the Digital Markets Act. We have seen that the goal of the Digital Markets Act is ensuring contestable and fair markets. Here in Article 1.5, we see that member states shall not impose further obligation on gatekeepers for the purpose of ensuring contestable and fair market. So where is the problem here again? The problem is that the concept of contestability and fairness are not well defined. And if we interpret in an extensive way this article, we risk that a large number of national rules and national legislation will not be applicable to gatekeepers. Why? Because, of course, many national legislation pursue the goal of contestability and, above all, fairness, which law is not fair. I mean, and what's the risk here again? Well, the risk is that gatekeepers will be exempted from complying with many national legislations, but competitors of gatekeepers will be not exempted. So the risk is that the competitors of gatekeepers, that are those who should contest the position of gatekeepers, would have additional burden compared to gatekeepers. And thus, the same goal of contestability could be affected. What is our solution? Our solution is the interpretation of the provision. Here you can see the elements of Article 1.5. So if all these conditions are met, then national legislation will not be applicable. So the first condition is it should be addressed to the gatekeepers. Second condition should provide for further obligation. The purpose, as we have seen, should be contestability and fairness. And then there are some elements within the scope of the DMA. What's the meaning of this provision? These are elements that are the result of our interpretation. So the last two elements are not explicitly provided in Article 1.5. In our opinion, within the scope of the DMA means that the legislation should specifically address core platform services. Why is this important? We just try to make some hypotheses of some possible national legislation and trying to understand whether this national legislation would or would not be prevented according to the DMA. Unfair competition rules. Of course, these are unfair competition rules are widespread in many member states. They can be different, of course, but we can make an hypothesis that, for example, boycott is considered unfair and so is prohibited under some national legislation. Would this rule be prevented by Article 1.5? Let's see. Now, among the other C's of unfair competition rules, for sure we find gatekeepers because they are general rules. So all undertakings are subject usually to unfair competition rules. And of course, gatekeepers are also undertakings. It can provide for further obligation because boycott in itself is not prohibited under the DMA. The purpose of unfair competition rules, of course, the prohibition of unfair competition rules, of course, at least fairness is among the purposes. So if we stop here, we should say that unfair competition rules should not be applicable to gatekeepers. But then if we apply our interpretation, we find that yes, it can be core platform services because, as I said, it's a general rule, but this rule will not specifically address core platform services because it's a general rule. And thus, in our interpretation, unfair competition rules, of course, this is an hypothesis again, then we should see the details, but in general, we can say that they should not be prevented by Article 1.5. Another example, an obligation on streaming platforms, let's say a regulation on streaming platforms. Again, we see it can be among its addresses gatekeepers. Let's think about Amazon Prime Video. Amazon is a gatekeeper and Amazon Prime Video is a streaming platform. Further obligation is possible that it can impose as further obligation. Purpose also is absolutely possible that among the purposes there is contestability and fairness. Here, this legislation would specifically address a platform, but it will not be a core platform service because streaming platforms are not among the core platform services identified in the Digital Markets Act. One last example, prohibition of fees for in-app purchases. Now, the situation that we have now very often is that app stores impose to app developers that distribute their applications through app stores to pay a fee for the purchases of users to the benefit of the app developers. So let's imagine an application, gaming application, where you can maybe buy some tools within the application. In this case, when the user buy something within the app, then a commission, a fee, has to be paid to the app store. These are widely discussed contractual provisions. So we can imagine, as far as I know, we don't have yet this kind of regulation, but we can imagine that in the future, a member state could decide to prohibit this kind of fees. Of course, among the addresses, we would add gatekeepers. Again, this is a further obligation because a prohibition is not provided in the DMA. There are some measures that aim to solve somehow this issue, but we don't have a prohibition. Contestability and fairness, of course, can be among the scopes, the purposes. And in this case, this prohibition, this obligation would specifically address core platform services. So this is the last one, is the kind of provision that is not, is exactly within the scope of the DMA, and thus member states should not legislate in this matter. If they do, of course, this legislation, this rule would be inapplicable. All what I have said until now does not apply to competition rules because they have a different discipline, and now Germán will talk about competition rules in particular.
Thank you, Giulio. Thanks, Volker, for the invitation. Yeah, so I will talk a bit about the interplay between DMA and competition laws. This is regulated in DMA in Article 1, Paragraph 6, the next one after the one mentioned by Giulio. And it establishes like 3 different cases. The first one, all of them referring to the possible parallel application of the DMA on the one hand and a competition law on the other hand. The first case refers to Articles 101 and 102 of the Treaty of the Functioning of the European Union. The first one refers to traditional horizontal agreements, cartels, and the 102 to abuses of dominant position. And it is worth mentioning here that it's not only the Commission, but also national competition authorities, the ones who can enforce these European competition rules. And indeed, according to Regulation 1/2003 on the implementation of competition laws, the national competition authorities, they should refer to European competition law Articles 101 and 102 when they enforce cases on horizontal agreements and abuses of dominance. Then we have a second case in which it is also possible to have a parallel application of the DMA and national competition rules that are different from Article 101 and 102, and specifically rules that sanction different forms of unilateral conducts that are not based on dominant power. But here we find a limitation, so that can be, this infringement can be enforced by national authorities insofar as they are applied to undertakings other than gatekeepers, or if they are applied to gatekeepers, refer to imposition of what they call further obligations. We will see that with respect to this case, there are some interpretation issues that we address in our position statement. And then the third case refers to the parallel application concerning merger control. So can you put the next? Thanks. So first of all, the first question is like why there is a justification for a parallel application with respect to competition laws. Here there is formal answer to that, which is the demarcation that one can find in the DMA, specifically in recital number 11, with respect to the different goals that these two pieces of legislations have. On the one hand, the DMA refers to fairness and contestability. On the other hand, the DMA says that competition law is about distortions of competition. So, but we all know that this formal demarcation is much more complex in reality. And when we look at the substantive aspects of infringements, we see that we can have overlaps. And this is even more clear when we see that so most of the DMA obligations that are listed in Article 5 to 7 are inspired in competition law cases. Just to mention one, self-preferencing is one of the obligations of the DMA, and it is still discussed in competition law enforcement now in the Google shopping case, and now in the last stage before the European Court of Justice. So we see that overlaps are clearly possible, but then the question is like why an overlap would be a problem. So first, because as Giulio mentioned, there is risk of fragmentation of the European single market if we have different rules, different application of these rules. Secondly, we see some possible practical implementation problems if obligations are different, and so gatekeepers have to comply with them, but in a different way that makes that difficult, or the compatibility in the compliance is not possible. So that can mean an excessive burden, which lead to possible annulments of decisions due to aspects related to proportionality. And finally, there is a risk of non-bis in idem, which if we are talking about the enforcement of identical conducts, but from from competition law and the DMA. So all this justifies the existence of Article 1.6 indeed implementation rules, but then when we see what is the treatment of traditional competition law in this regard, there is a parallelism without any sort of limitation. However, when we analyze like the relationship of like national competition authorities and the Commission in the context of cases that have effects in more than one member state, we can look at regulation, the regulation on the implementation of competition law, and we can see that the Commission has the power to take over cases that have been initiated by national competition authorities. So by using this power, we understand that so the Commission has some sort of control to avoid some parallel enforcement of competition cases at a national level, if that put in risk one of the overlapping problems that we have mentioned before. It is different with stricter national competition rules because the Commission does not have the same power because those rules are not European 101, 102 traditional competition rules, but have a national dimension. And exactly because of that, the hypothesis of or the limitation of Article 1.6b has a different dimension than the parallelism that is allowed according to traditional competition rules. Can you move to the next one? And that needs some sort of interpretation that is something that we address in our position statement. So coming back to what Article 1.6b establishes, so basically that the DMA is applicable without the prejudice of national competition rules prohibiting other forms of unilateral conduct insofar as they are applied to undertakings other than gatekeepers or amount to the imposition of further obligations on gatekeepers. Here, there are two concepts that are not clear in our eyes, and which are like, I mean, what is competition rules and what are further obligations in the context of Article 1.6b that required some interpretation to avoid inconsistencies in the enforcement of DMA and competition law. So what does competition rules mean? We see here that it would be risky to leave the decision of what competition rules means to the discretion of member states, because just to give one example, one member state can eventually decide to regulate core platform service based on fairness, motivations, and that would be prohibited under Article 1.5 according what was explained by Giulio, but because they call this regulation competition law, they could, in a formal way, try to circumvent that prohibition, and that will, of course, risk fragmentation in the application of the law. So we understand that to interpret competition rules in the context of Article 1.6, we need we need a uniform concept of competition rules that is applicable to the European Union in general. So we draw on Regulation 1/2003 and Recital 10 of the DMA to find those criteria that allows us to have some idea of what competition rules are in the context of the DMA. The Regulation 1/2003 provides explicitly a scope to forms of market power that are different from market dominance. And then Recital 10 of the DMA, taking a rather procedural approach, describes competition rules as the one in which there is an individualized assessment of market positions and behavioral aspects, and it gives room for efficiency and objective justifications. So considering these three criteria, we think that we can provide a uniform and enough broad concept of what competition rules mean in the context of Article 1.6b. And just to give an example in this regard, what wouldn't be competition law would be, for example, a blacklist unfair commercial practices because of the direct application in which there's no assessment of market positions, and there is no possibility of objective justifications by defendants. What would be, on the contrary, competition law would be, for example, the new section 19A of the German Competition Act, which establishes a new form of economic power that is different from dominance, in which related to companies with a paramount significance for competition across markets, a case in which the Bundeskartellamt can set some restrictions in order to avoid anti-competitive effects, both exclusionary and exploitative, and there is place for objective justifications. So all the criteria that we mentioned that would allow us to define this provision as competition law are met. Then the second problem refers to what does further obligations mean in the context of Article 16b. So clearly, these further obligations cannot overlap with those provided in Article 5 to 7 of the DMA, which means that the national competition authorities have discretion to impose, on the one hand, obligations to core platform services, but they have to be different from the one already in the DMA. And they can also impose obligations to other sort of services that can be identical or different from the obligations enlisted in the DMA, in the designation of the specific gatekeeper, of course. So this is how we interpret that that rule, that implementation rule. And it is very nice that we can see nowadays in Germany an example that I think that illustrates quite well how this interplay of competition law and the DMA is taking place in reality. So this is a Bundeskartellamt case proceeding initiated against Google with respect to the use and combination of personal data across platforms. And the interesting part is that this case was initiated based on Section 19A of the German Competition Act, which means non-traditional competition law on dominant abuses, but competition, I mean, the economic power hypothesis referring to the paramount significance across markets. So the interesting part is that at some point, Google offers commitments. So the case was closed in some months ago due to these commitments. The commitments are aimed at avoid personal data combination across platforms. But the interesting part, if you go to the decision by Bundeskartellamt, is that these commitments refer to more than 25 services that are not the services that are subject to the DMA. So basically, all the core platform services enlisted in the designation of Google pursuant to DMA are excluded from this decision. And also it's interesting to see that the Fitbit service is also excluded from this decision. Why Fitbit? Because Google acquired Fitbit some years ago through a merger control process in which the merger was clear, but with some remedies, and one of them refer to same obligations with respect to the use of data across platforms by Google. So here is wonderful to see how so with the same aim, so to say, with the same aim of setting some obligations in how, with respect to how Google can use personal data across their platforms, we see on the one hand, the DMA in place, on the other hand, in a complementary way, a national competition authority, and also how merger control also contributed to create this this more complete framework with respect to this specific obligation, data-related obligation. So we can see here two of the main principles and mechanisms that we also highlight in our position statement, which are the cooperation and the coordination between agencies. It is interesting to see that the Bundeskartellamt also mentioned the regular and close contact with the Commission and data protection authorities before coming with this decision with respect to Google. And with respect to coordination, it is quite relevant to mention that the commitments, the obligation specified in the commitments have a substantive correspondence with the DMA obligations in order to ensure uniformity and thus avoid so practical application issues. So I think that with that, I finish my presentation with example. And so in the position statement, we also touch some other topics. So we invite you to have a look at it, to read it, and please happy to initiate the discussion. Thank you very much.